Employees Provident Fund and Miscellaneous Provisions Act 1952. The Act passed by central government aims to provide social security and timely monetary assistance to industrial employees and their families. The Act applies to every factory engaged in any industry and other establishments as specified in Schedule 1 to the Act and where 20 or more persons are employed. And it also applies to those industries and establishments as notified by central government from time to time. However, it doesn't apply to a cooperative society, and it also doesn't apply to an establishment permitted by EPFO to have their own internal schemes which are considered to be similar or better than the statutory schemes. The monthly pay under the Act includes 4 components: basic wages, dearness allowance, retaining allowance, and cash value of food concessions. In Regional Provident Fund versus Vivekananda Vidya Mandir and others case, the Supreme Court has given a decision in 2019 which is pending for implementation. It said special allowances to form part of basic wage while making PF contribution calculations. Monthly pay shall include basic DA retaining allowance, value of food concessions plus special allowances. Special allowances are those paid at fixed rate such as education allowance, conveyance allowance, telephone allowance, etc. But variable allowances payable only to a particular category of employees is not a part of special allowances. The term employee covers only persons employed in the normal course of business in or in connection with a factory or establishment. It includes those employed through a contractor. It may include a sweeper, watchman, and a gardener, but it excludes an apprentice, casual employee, or anyone employed for a short duration or for a contingent vacancy. And it also doesn't include an employee whose salary exceeds rupees 15,000 per month when the Act applies to an industry or establishment for the first time. Every employee is required to be a member from the date of joining. Once an employee is a member, he continues to be a member even where subsequent to his joining, his salary exceeds the ceiling of rupees 15,000 per month. What is crucial is the employer-employee relationship for coverage under the Act. Employer in respect of a factory means the owner or occupier of the factory. It includes the agent of such owner or occupier, and it also includes the legal representative of a deceased owner or occupier. In respect of any other establishment, it includes the person having ultimate control over the affairs of the establishment. Employer is also called an occupier, and it includes MD, manager, and CEO. Employees Provident Fund Scheme, Employees Pension Scheme, and Employees Deposit Linked Insurance Scheme, the 3 components. The scheme envisages contribution to EPF account based on monthly wages of an employee. Every employer liable to pay 12% as his monthly contribution, which is apportioned between Employee Pension Scheme 8.33% and Employee Provident Fund 3.67%. An employee is required to contribute equally with the employer, but his contribution goes fully into EPF account. He may pay more also voluntarily, and it is the duty of employer to deduct employee's contribution and remit the aggregate amount by 15th of the following month. The Employee Provident Fund Organization of India, EPFO, implements the EPF scheme. Its Board of Trustees invest the funds from the contribution as per plan approved by central government, and the return generated is given to members as annual interest credit at rates finally decided by the government. Funds lying to the credit of an employee are permitted to be partially withdrawn subject to some limits and terms. The purposes include medical, marriage of children, education of self and child, purchase of land for house construction, construction of a house, home loan repayment, and house renovation. The Act permits withdrawal up to 90% in a special case within 1 year before retirement and the age to be not less than 54 years. Complete withdrawal is allowed on retirement, death, permanent disability, superannuation, or retrenchment. Employees enrolled with the Provident Fund become members of EPS automatically. Government adds 1.16% to the contribution of employer. For getting pension, one has to put in an aggregate service of 10 years. Monthly pension made available from 58 years of age until death. Where a person is not able to accumulate the minimum service of 10 years, he is permitted to withdraw accumulations under EPS and EPF schemes. Pension is also payable on permanent disability, superannuation, and completion of 58 years of age. The monthly pension formula is pensionable salary into pensionable service divided by 70, and pensionable salary is monthly basic plus DA averaged over last 60 months of service, and pensionable service is years employed till retirement, and the number is capped at 35 years. In the calculation of service, 6 months and above rounded off to 1 year and less than 6 months is ignored. EDLI offers financial support to families in case of demise of the member. Any employee who has an EPF account becomes eligible automatically. No requirement to pay any premium for the employee. Employer contributes a nominal amount of 0.5% of rupees 15,000 or rupees 75 per month. Nomination under the EPF Act is considered as nomination also for EDLI. EDLI insurance benefit is payable for death after a service of 12 months, payable to the nominee. It comprises two components. One is 30 times the average monthly wages with a ceiling of 15,000 per month for the preceding 12 months, and 50% of average balance in EPF subject to a ceiling of 2,50,000. Both put together, the minimum compensation is rupees 2.5 lakhs with a ceiling of rupees 7 lakhs. Provident Fund Commissioner is the authorized officer with the power to determine the amount due from any employer. Employees Provident Fund's Appellate Tribunal hears appeal against order passed by the authority. If a company goes into liquidation, its employees have first claim on its assets for their EPF dues. Credit of any member in the fund is not liable to attachment under any decree or order. No employer to reduce entitlement per terms by reason only of his liability under the Act. Payment of Gratuity Act 1972. A social security legislation from the central government applicable to employees engaged in factories, shops or other establishments employing 10 or more employees on any day in the preceding 12 months. It covers any person other than an apprentice employed for wages in any kind of work, manual, or otherwise. It is a gratuitous gift from the employer made at the end of the period of employment. The Act stipulates 5 full years of continuous service with the current employer for payment of gratuity. The requirement is not applicable in case of death or disablement due to accident or illness. As held in Mettur Birdsell Limited, Madras versus Regional Labour Commissioner, 5 full years is also equivalent to 4 years and 240 days of continuous service. And in the case of 5 days in a week working system, it is stipulated that mere 4 years and 190 days can be considered as a compliance of requisite continuous service. Continuous service implies service without interruptions. Continuity is assumed to have been not affected where the break is due to reasons beyond one's control, or the break is not voluntary, or the break comprises of any paid leave, temporary disablement, maternity leave, layoff, strike, or a lockout. Terminal benefit is payable on any of the 3 situations: on superannuation, that is attainment of age fixed in the contract, or on retirement, resignation, or termination of service, or in the event of death or disablement caused by accident or disease. Rupees 20 lakhs is the maximum limit for total gratuity in one's lifetime, and this is once again subject to the prescribed gratuity formula. However, it is open to an employer to contract to pay more than the amount of maximum limit, but anything outside the gratuity formula will be taxable in the hands of the employee. Gratuity is calculated for the entire period starting from the date of joining till the last working day. Gratuity equals last drawn monthly salary into 15/26 into number of years service. Last drawn salary includes basic salary plus dearness allowance. 15/26 represents 15 days out of 26 working days in a month, and service less than 1 year, if it is 6 months and in excess of 6 months, is rounded off as 1 year. An employee is required to make a nomination within 30 days of completion of 1 year of service. Nomination shall be made in favor of one or more members of family. Family includes spouse, children, dependent parents, widow, and children of predeceased son. In the absence of family, nomination can be made in favor of any person. However, whenever a person acquires a family, it is mandatory to make a fresh nomination within 90 days. Gratuity payable on the death of an employee shall be paid to the nominee. If no nomination has been made, payment shall be made to the legal heirs. A legal heir can apply within 1 year from the day the gratuity is payable. If the nominee or legal heir are minor, the gratuity is deposited by the employer with the controlling authority until such minor attains majority. Forfeiture is permitted after a due process of law of show cause, hearing, and termination. To the extent of loss, forfeiture is permitted for any act, omission, or negligence causing damage, loss, or destruction of property. Wholly or partially, forfeiture is permitted for riotous or disorderly conduct or any other act of violence on the part of the employee. Similarly, forfeiture is permitted for any act which constitutes an offence involving moral turpitude, but the only condition is it has to be in the course of employment and only after court conviction is obtained under law. A person entitled to gratuity shall make an application to the employer, and the application shall be made within 30 days ahead of the date it becomes payable, and the employer shall determine the amount of gratuity and give notice specifying the amount to whom payable, and he will intimate the controlling authority to that effect. The employer is obliged to pay the amount of gratuity within 30 days from the date it becomes payable to the eligible employee or his nominee or legal heir by check, draft or through net banking, and he shall report the details to the controlling authority simultaneously. If there is a delay in the payment of gratuity, interest at the rate of 10% per annum is payable for the duration, except when the delay is due to the employee or the delay has been permitted by the controlling authority. The employer shall deposit with the controlling authority the amount as he admits to be payable whenever there is a dispute as to the amount of gratuity or on the admissibility of any claim, or in relation to an employee or as to the person entitled to receive the gratuity there is an issue. The controlling authority shall hear and review the case in order to ensure that the dispute is settled and the deposit is rightly paid to the applicant or nominee as applicable. Controlling authority is appointed by the appropriate government, and he will be responsible for administration of the act in the specified location. Employer, employee, nominee or any other aggrieved may apply to controlling authority within 90 days for disputes involving refusal to accept nomination, refusal to accept gratuity application, or where the employer indicates lesser amount as eligible gratuity, and similar matters. The controlling authority has court powers on getting attendance, documents, evidence and issuing commission. It can pass orders after hearing with reasons and direct employer to pay such amount, and anyone aggrieved from the order of controlling authority may appeal within 60 days to the appropriate government, but the requirement is that can be done only after depositing the amount of gratuity payable as per the order of controlling authority. Gratuity, if not paid as per order, is recoverable as an arrear of land revenue with interest at the rate of 9% per annum.